Live at the end of the day, we brought all these privacy women together and we are going to dissect the recent overturning of the Chevron Doctrine with the Loper case. I came about this because all these women were talking about it and we all decided we really needed to hash this out. My name is Violet Sullivan. All of the people on this session are LinkedIn Live, representing their own views, not that of their companies, and the statements made are not that of their companies. So we're coming on here as privacy friends. My background, I'm a part of the insurance world of privacy and cyber. And Heidi, I'll pass it over to you and we can round robin intro and then get into it.
Awesome. Thanks for putting this together, Violet. My name is Heidi Sass. I'm a data privacy and technology attorney. These are my personal opinions, not legal advice. I chase data brokers. I also work with businesses and privacy pro, lawyer, all those fun things mixed into one. Right now, I dissent, but we'll get to that in a minute. Kay.
If you want really short, I just say, hi, I'm Kay. But aside from that, I've been in privacy a long time, and now I find myself back in the insurance world with Violet, where we met originally. I do a podcast series, Privacy, and you'll usually find me on everything under Heart of Privacy. And since I have severe ADD, I'm going to say, Violet, I really think you need to start doing things at the end of the day.
Well,
this is your statement. At the end of the day, this is your show.
This is the first time I've tried this time. So thanks for the feedback. We'll see if
I love it.
We're talking to a wall or not. Winner, go ahead and introduce yourself.
Hi, I'm Winter Deagle. I'm a privacy litigator. So 100% of my practice at the law firm Shepherd Mullen relates to privacy and cybersecurity litigation. And I also do some counseling around compliance for various clients. But I've been doing this, I guess, about 17 years now, all in the privacy area.
Well, this is actually, Winter and I have exchanged emails, but this is the first time we've been on virtual screen together. So meet everybody, right? We're all meeting. What I guess I'm curious is how many of you immediately got questions over the last couple of weeks pertaining to this issue, right? And tell me the most bizarre questions you got. Heidi, I know you've got some weird questions that came your way.
Can I fire the compliance department and just stick with the law firm? Like, for real. Can I fire the compliance department now? Because I read this article from this banker and this law firm, and they were like, woohoo, they're throwing away books, and we're doing everything. There's a new sheriff in town, and like, yeah. So, yeah, like, can I, don't go shutting down your DSR portals, and no, you can't fire the compliance department right now. Like, no. So how about you guys? Beat that.
That was not on my bingo card.
I got to ask my client if they could just tell the FTC to F off now.
That's kind of what I got, but I will say one of the more interesting ones I got is, in addition to the FTC, does that mean the CPPA goes away?
Yes.
So,
and just in time for, they announced CPA just announced that they have the board meeting July 16th. So they're about to throw out more enforcement actions predictions, but I wonder if this is going to change things.
So, no, I think I want to back up a little bit here. I want to try and make this a little bit more accessible for other people who are, maybe not lawyers, because we all are. And, we do lawyer speak, and, it's confusing for people sometimes. So let's back up a little bit and let's talk about Article 3 courts. Article 3 refers to the Constitution. These are the judges that are nominated by the president, confirmed by the Senate, and then seated on the bench. That's all three branches of government. You've got checks and balances, but it kind of stops there. For the judiciary, they don't really have a lot. It's largely unchecked power. But those judges are different than your state court judges, where you go, and family court judges, where you go to get a divorce, child custody, or if you go into bankruptcy. Those are federal judges, but that's different because Congress created those bankruptcy courts, not the Constitution. So there are 94 trial courts, 94. So that's how many different options you have to choose from. Like if you thought it was tough watching through 2 or 3 regulators to find out what's going on with rulemaking, try watching 94 dockets at the same time. Plus you've got the appellate court. So, and that's 12 federal circuits right there. Plus, I mean, it's going to be a problem moving forward if you don't have alignment with an attorney if you're working in privacy. And I think that's a big disadvantage moving forward. That's one of my negatives as far as everything that's happening right now. But I think it's important to let people know, like, what does this affect? What type of courts are we talking about? And then we can start talking about what the decision did, right? You guys are professors, right? I think all of you are professors but me.
Yeah.
I think we've even, I feel like Kay has spoken in one of my classes too. So I think there's some crossover. But
yeah, exactly. And I think in light of the talking about the federal courts, it's a little behooves us to put in context if there are non-lawyers watching or lawyers that don't actually work in the area of law that has to deal with Chevron deference, to understand why this really matters to us. Chevron was decided in 1984. All of our admin law classes in law school were based on Chevron. Because what it means is if a statute is ambiguous and it's under that agency's jurisdiction, the agency is the one that gets to decide what it actually means. We have lots of agencies. And the one that we deal with most in privacy is probably FTC in general, but you've also got the Department of Education for FERPA. You've got OCR for HIPAA. You've got whoever the heck wants to jump in on GLBA. For things like that. And so they're the ones that have been enforcing privacy. You see more enforcement out of a couple rather than you do many of them. And now the court is saying, oh, wow, judicial courts don't have to defer to the agency expertise anymore. And that really matters because Congress is not always very clear in what the law should be. They might try to be, but think of all the new technologies that we have that come out, and laws cannot keep up with that because to be very specific on a law, you have to be very current on a law. And that makes a big difference for the courts. And not all state courts follow Chevron. State courts can follow Chevron or not. I actually looked up how many actually follow Chevron and how many don't. They tend to go more with what's called the Skidmore deference, which is a lower level, meaning that you can listen to the expertise of the agencies, but you're not forced to defer to them. And so now we're kind of back to that deference on the federal level as well, is you can ask for their expertise, but the courts are not required to defer to them. Now, the funniest thing I think about this is back when I was getting my PhD in public affairs, the first question they asked us for the first class was which branch of the federal government wielded the most power. And of course, I said the judiciary. And my professor said in his 45 years of teaching, he had never once had anyone assert that the judiciary had the greatest power. Well, now we're about to find out.
Mm-hmm. And what they do with that.
Right, exactly. And it depends on who's on the court. As Heidi said, you have 94 trial courts federally. You have the district courts that have it. All of them bubble up to the Supreme Court, but they don't all. They get petitioned for 3,000 cases a year, 5,000 cases a year, and they might hear 200. So if you have appellate courts that are in contention with each other, much less the trial courts, just look at the appellate courts, you may have districts that go vastly different ways on it. Unless the Supreme Court speaks on it, you're not going to have any conformity across the land.
Mm-hmm.
And I think, the interesting thing for me as well is part of the early comments that I saw on this were, well, it's great. It's going to make it less political. But if you really think about it, how are these judges appointed? To go back to Heidi's point, these are Article 3 judges. They're political appointees. So if anything, all it did was switch from one set of political appointees to another set of political appointees.
Maybe
Yeah,
a smaller set, but perhaps a more powerful set, right?
I'm going to drop an opinion from the Ninth Circuit that came out today about a district court judge in Alaska that was just awful. And he resigned, right? He resigned shamefully and rightfully so. But I'm also going to drop in, a website called Fix the Court. Because it's got a lot of great ideas about what can be done to help with this, because it's largely unchecked power, and whether you know it or not, if you're a clerk and you work for a judge and you're sexually harassed, our laws will not protect you. They carved that out specifically because the judiciary did not want Congress interfering with their own internal affairs. So, right. So, I mean, the power concentration, I mean, quite frankly, this may be shocking and I just don't care. But whenever the court invokes Marbury versus Madison, they're about to do judicial dick swinging and power grabbing. And the Chief Justice did not disappoint. He said Chevron is overruled. He went a little bit further, and I want to bring this up. It said, by overruling Chevron, though, the court does not call into question prior cases that relied on Chevron framework, right? Including the Clean Air Act itself, he says. Who here thinks that's going to work?
No. They say you can't overturn stare decisis but you can't ignore it just because it was based on a flawed logic.
But
so
if you get it
how
wrong,
are they going to overcome the flawed logic? By saying, oops, it doesn't apply.
Well, if you get it wrong, it's going to come back up to them and they'll let you know if you got it wrong, because they're giving a lot of guidelines here. Another paper I'm going to drop in here is a paper from I think the Harvard Law Review that was put out last year. Because I don't know about you guys, but after Dobbs, I sent the family to the beach for the weekend for the 4th of July, and I stayed home with the Constitution, specifically the 10th Amendment and Justice Thomas's opinions. I wanted to know, where is this going? Well, now we know, because Project 2025 has been published, and you can see where the rest of it's going. But I mean, first was Roe, and they wanted to get rid of that. So the 6-3 brought you Dobbs. And now they're looking to go after Dodd-Frank. In that vein, they issued their ruling in SEC versus Jarchese. That's another one that came out this session. It's aimed at Dodd-Frank, but it's about the 7th Amendment right to a jury trial. Which, Winter, I would love to hear what you have to say about this. Would you advise your clients to go into a jury trial in one of these situations instead of an in-house regulatory issue? Like, are you going to trust the judge to know what the hell they're talking about? Are you going to be comfortable going through the discovery process? Are you going to want that going out to a jury? Like, I mean, it takes 9 to 12 months to even get past summary judgment in a lot of cases right now in the federal courts. So really, how long and how expensive can this be for people?
Yeah, it's funny. I was thinking about that myself, and it's not 9 to 12 months anymore. I mean, if you look at the backup that we've got, let's just say California alone. The backup, I recently requested a motion to dismiss hearing. That hearing is in mid-2025. And for you non-lawyers, that's like the first motion that you file.
Yeah.
So my hearing's in 2025. So when we're talking about swift administration of justice, this ain't going to be it.
That's relevant, right?
I mean, the other thing too is, my dad likes to say, Winter, all the people that you're talking to on the jury, those are the people that were too stupid to get out of jury duty.
And they don't like lawyers in the jury. So You're not going to get that objective viewpoint either.
Now, that's a very cynical view of our jury system today, right? But who are you going to trust more? Are you going to trust the jury on complicated laws like privacy laws when half the scholars don't even agree on what they say and what they mean,
right,
and don't understand the technology? Or are you going to trust a political appointee judge who maybe is also not motivated to understand the technology, and there's only one of them? And so I think when you're looking at this shift, at least when we were dealing with regulatory authorities, you might not agree. But most of those people are experts in the area that we're talking about. You may not agree with where they're coming out, but they're not sitting there going, well, what exactly does privacy mean?
Yeah. Well, and we're going to see a whole lot of motions to overrule or overturn decisions, because the court also said that, 6 years on the administrative
Corner post. Yep, corner
Yeah.
post. 6 years.
Yeah.
You don't like the rule, go back.
Thank
6
you.
years.
I was tongue-tied there. Yeah.
Do it. Yep. It's
And not
easy to
6
get on
years
down
from when
litigation.
it was passed, but 6 years from when the person was injured by it.
Yep.
And they don't mean that the passing of it injured the person. They mean when the person did something to where the passing of it actually impacted them directly. So this could go on for God only knows how long.
I mean, I'm grateful for permanent employment. Don't get me wrong, right? But
It's given winter a lot to do.
I mean,
We don't need job security. We don't need more job security. We have plenty of job security.
that's the thing. We've got plenty of job security with the current set of regulations. We didn't need the additional security here.
Yeah.
Well, go back to the backlog, because I think what we're going to see, you mentioned the backlog already, right? As it exists before Chevron 2 weeks ago through whenever this, I don't remember the actual dead date. But now we're going to see all of these people that assumed that they couldn't push back, now file. What do you think about the increase that we're going to see of people trying to go to the court, assuming they might get more favorable because they wouldn't get favorable in front of the FTC or otherwise?
Look, I mean, judges right now are overworked and understaffed.
Yeah.
They don't have enough clerks. There aren't enough of the judges. They're low on magistrates. Part of that is because the appointee process is held up because they can't agree on anything in Congress.
Right.
And once we get close to an election, no one's willing to do anything until we wait to see how it shakes out, right? We're going to be at a crisis point in the courts, I think, in very short order. Because
well, and is this a push to staff to expand the court to create more?
Chuck Schumer, can you get some floor votes going? Hello. I'm dead serious. Like, I don't care what you do for recess, but before recess and after, you need to see some judges. Like, seriously, we've got like 100 in the hopper right now. Just schedule floor votes like all day long. Yeah.
I also think you're going to have some very short-tempered judges that right now, right? You go into federal court, they do not want to deal with discovery disputes. They don't want to deal with any pettiness. No. There is a real push to clear the docket and to not have the docket go past 12 months, because then you get on the naughty list. So the push that you already see towards settlement in some of these non-APA cases is going to get even heavier. So when we're talking about how much justice is justice, courts are already putting a lot of pressure on litigants to get out of my courtroom, right?
Yeah.
I mean,
feel that pain right now.
Right.
I drafted my first appellate brief last week. Yes, it took 10 months to get dismissed. Now it's going to the appellate court. I hear you. Article 3 courts, standing is a problem. It's a liberal standard to be applied, but they do not apply it evenly in all the different courts. So, I mean, that's just one more fun thing to look after. Also, depending upon the issue that you have with your business and you're trying to defend your business or advise them, not all of the laws that Congress has passed give the agencies the power to even go into court to provide them that jury trial. So, a lot of the agency laws that they have, Congress has relied upon the deference, formula to say, we're going to let the experts fill in the gaps here. And so we no longer have that benefit. It's already a clown show trying to watch, industry people and lobbyists draft legislation. It's clown show because they put in a lot of Easter eggs that they go and chip away at later in the courts if it gets passed. Not a lot's getting passed right now, but that's how legislation is drafted. So moving forward, until you don't have any ambiguities whatsoever, it's going to have to be bulletproof drafting, and that will never.
We don't have time for that. No one has time for that.
All of the people that have been bought and sold in Congress, like it's never going to get there. There's another hearing about AI and privacy on Thursdays. Anybody going? Because I think it's a pony show, and I'm not wasting my time. Anybody going? Exactly.
Why do you think it's a comedy show, Heidi?
Well, I think my question, though, for you, right, is let's talk about who's going to pay for it.
Yeah.
How much is this going to upend the insurance market? And how much do you think it's going to be harder for companies? Right now, the cyber market is tight already. Yeah. How much harder do you think it's going to be?
Your risk pool are screwed.
Yeah. I think that plaintiffs' lawyers especially are going to see this definitely as a windfall. to look at. I mean, we already see
They've
so
already
many
had a
lawsuits
windfall
out
for
of
the last
control.
18 months. They've
I
been
was
going.
going to say, yeah, it's been pretty
It's
good
going to be
for a
even
while.
more so. It's going to be a free for all. It's no longer a landfall. It's a free for all. But I think it's going to go absolutely crazy. But here's the thing: the judges can defer to the agencies. The judges are the ones that the court is saying are empowered to make these decisions. Most of the judges don't have the knowledge. I do see them actually taking in expert assistance in whether it's in amicus briefs or whether it's the court hiring a consultant or whatever. I do see that becoming more par for the course, that the judges are going to do it and they're going to look for more training in the hot topics. But look at us. We've been in the field for decades, multiple decades. We're a centurion if we add them all together. And we wouldn't proclaim ourselves to be experts in privacy. We would say we need to go out and research and learn more before we can come to something. I can't imagine what these judges are going to feel with the extra burden on them.
I don't know that they're going to feel that burden. That's just where I'm at with that. I mean,
they're not going to have time, or they're going to enjoy it.
I think it's you don't know what you don't know. A lot of times, and you think about think about the state Winter said that they were in this overworked, wanting to get it through. Why would we waste the time? If I'm cynical, why would I waste the time as a judge reading that brief to educate myself when I can
just have AI summarize the briefs for them? What are you talking about?
They don't. They're scared to use AI. Every lawyer I talk to is too scared to use it unless they're in privacy or cyber.
Oh my God! If they're in personal injury, they're using AI out the wazoo. Trust me.
Well, plaintiffs. I would say the defense attorneys. I've seen multiple defense attorney firms that have outlawed it completely, not realizing it's right here. But we're not on AI, so I won't get on that.
It's going to lead though to more forum shopping, right? There are certain judges that aren't going to defer to anybody. Like, let's be real.
The conference is talking about it. I mean, they've thrown some shade at, the judge shopping, and the fifth got lit up pretty good, even by our boy Clarence. He lit up on an associational standing and was like, I don't know if that's going to apply for all these cases. Because, I mean, they've built these groups of people, and they're like, I've been injured, and they sue, and they don't win. And they're like, well, I've been injured too. And so, I don't know how many people you can bring on that kind of bus. And even the court's tired of that. Plus, they had a hefty docket themselves. I'm worried about the shadow docket, because the shadow docket is taking over, and they're getting more and more cases that are trying to get fast tracked up to the shadow docket. I'm encouraged to see them kick things back when they don't even clear the hurdles in lower courts. That's somewhat encouraging. But I really do think that we're going to have problems moving forward because there are so many different courts, and it's open to interpretation. It kind of depends on the risk tolerance for your company and what your company does. So just because you're right doesn't mean you're going to win if you go to court. You might be able to buy yourself more time. Exactly. But it still costs real time and money to get you out of trouble you may or may not be in. So this is a strategic decision to make with a business to say, do you really want to dance in the gray area and have knee-jerk reactions every time another state is added? Or do you really want to go ahead and invest in this and move forward so that you can have some sense of confidence and build trust with consumers who are using your products?
What about
and
overall
let's be fair,
risk,
Heidi. Go ahead.
Okay, I want to throw it back to you because I want to say overall risk. This is affecting every area of risk. So how do compliance departments, back to Heidi's point, and risk managers, how are they going to get their hands around the increase in volatility that this is going to create to not only privacy, cyber, but all of the other pieces
Other
as well.
compliance areas, including one of the questions that we got on the SEC and their authority.
Right.
So it is interesting I'm not even sure how to brace for what the impact may be.
That's
I sit here and I go,
the person I'd call. Okay, how do I
Ghostbusters, please. How do you brace for something like this that we've never seen something on this scale before? We sit here and we say,
I need to go back to law school or something right now. I feel the need to go back.
The courts are already overwhelmed. The plaintiff lawyers are out of control. The agency rule has been called the fourth branch of government for years, because they essentially have the powers of all three branches encapsulated within their agency. So I do see where some politicians, those politicians can be judges or justices, would say the agencies have too much power, and this was a way to get that power away from them. I do see that as being a perspective, but how do we as a company objectively say, okay, this is the level of risk that we're facing until we start getting hit with it, until the market, as you might say, starts responding to it? And I expect that's going to be pretty quick, frankly. Is it going to impact the state courts? No, but most of us aren't dealing with the state courts, are we?
No, I would say stay the course is what I'm telling people, because you've already invested. You've got your privacy maturity at this level. Like, stay the course is what you need to do, because you don't know how this is going to play out.
No.
But the safer, the better, because the first thing people ask is when something bad happens is, well, what were you doing about it? What did you do?
What did you have in place? And that's what I was going to say when you said, is the business prepared to accept the risk? Got to be careful. The business people will accept a whole heck of a lot more than your legal and your compliance department with. The business people will be like, yeah, let's go for it. Let's do it. And the legal's going, oh, hell no. Right. Not touching that one. Heck no. So I do think it's going to almost be a hide and wait, prepare for the worst, hope for the slightly better. I can't say hope for the best. I don't think there's going to be a best coming out of this. Getting Congress to write the laws with more clarity is pie in the sky. If I can throw any more metaphors at it, I will.
We can't even get a national privacy law together.
Right. Can we get a federal privacy law that is very clear and speaks to all of the issues and has no ambiguity in it whatsoever? Oh, good God, we're in privacy. We live in ambiguity.
We know that it's been years and years and years in the making, and it's not going to happen this year either.
No, this means that the law is going to be further away. This means that if they have to write it with no ambiguity, it means we're not anywhere close to a federal privacy law.
So two things that have already happened since Chevron came down. One is the FTC rule on the extended overtime pay was challenged in on Friday afternoon. Yep. Yeah, they went ahead and put a stay on that ruling as well. So, and the other one was in intellectual property. The intellectual property rights, Google is all over everything. But they have already filed documents to the Court of Appeals to take another look, just in case the Chevron deference got thrown out, take another look at an issue that they have with the speaker maker Sonos. And so, I mean, that's right. That's already happening. The lawyers are already out there.
Agencies are going to throw rulemaking out the window.
Mulligan, like it's a mulligan. They're throwing at the court, like, give me a mulligan. I got Chevron. And so, what I want to put out to people is just a little bit of reality here. Number one, we're currently in budget negotiations to fund our agencies, and the agencies protect all of our rights, businesses, consumers, all of our rights, because you can make more money if you don't have to follow any rules. But that is not how our government and our economy work. Yeah. So, they are cutting the budgets to the agencies right now. And so all of these different courts that we're talking about where, the agencies may be sued, they have to have boots on the ground to be sued there. Do they have enough lawyers to be sued there? Because it took a long time for us to get technologists working in the agencies. Now, do we have enough litigators working in all of the agencies? And what litigator wants to go and do this for an agency if they've got all these student loans and they're making government money when they can be out making mad cash? Right? Like, this is going to be a problem and fast. And so I kind of like some of the things that the agencies have been doing. Number one, they've been working on setting up rulemaking so that it does not have to rely on Chevron deference. And so they expect these challenges, but they also think they will succeed. Number two, they have been going and watering the flowers, talking to law school students and trying to get them excited about going and working in public service and working for the government agencies as well. And number three, they see what's coming. And so I don't know about you, but this is exactly why I would say the FTC has not issued rules on the ANPR for commercial surveillance yet, because they saw this coming. And so they are going to try to maybe button up everything else that they have so that it can withstand battle when it goes out. But I'm kind of concerned about cutting budgets for agencies that don't have enough lawyers to go out and defend all of these rules for the American people. That's going to run up our
and then we get bad law. what happens when we go in and get some bad law that now, as of the private sector, has to react and respond to and change
Right.
the whole compliance structure? So we have 1 minute left. Can we give like a final sentence, win or start? Because we've been talking a lot. You start.
Yeah.
What's your final parting sentence, and then toss it over?
We just saw this play out with the American Hospital Association lawsuit over tracking technology.
Yeah.
OCR responses, we're considering our options. It's just going to lead to multiple rounds of litigation. This one's in the Northern District of Texas. I'm keeping my eye on it to see what happens. But all we've done is create rounds and rounds and rounds of litigation.
Okay.
We've seen this coming. The agencies are getting powerful, but I mean, we do need the agencies. Congress can't do this. The judiciary can't do this. The executive branch can't do this. We do need the agencies. So whether you think they're too powerful or not, I mean, we need them. What's the alternative? And we don't have an alternative.
They're not done yet. Issued another settlement today. NGL and kids on an app, FTC, they threw another one. The CFPB also threw out some more stuff, settlement about auto loans and junk fees being charged. Not done. The administrative state lives on.
Well, I'll be interested to see the insurance perspective too, Kay. Kind of looking at the financial, like what is the anticipation of risk? Because we're going to be able to see what are people going to be coming for more of a parachute in the back. So,
I'd like to see how they quantify this.
Yeah. I mean, I don't know. We'll see. It's now been 30 minutes and it's been awesome talking to all of you ladies. I feel smarter just having sat through 30 minutes. So thank you so much. And I feel like we have to revisit this in 6 months and come back and say what hell has been raised from the Chevron Doctrine toppling over.
Chevron hell. I like it.
All right.